Hello, my name is David Winch. I'm a chartered accountant and forensic accountant with Bartfields Forensic Accountants. This is the part 2 of our discussion of the Law Commission's consultation on confiscation. We're going to start with a little chat about the consultation itself, which is kind of a reminder of things we covered last week in part 1, and then talk about the forum for confiscation hearings. Should they continue to be in the Crown Court? Should they be in a special court? And those sort of issues. How important is it, or is it not important, that the judge in the confiscation hearing is the same one who was the judge in the trial, if there's been a contested trial? Then we talk about benefit, and that's obviously a key area in confiscation. How do we define benefit? How do we calculate benefit? How do we split benefit between co-defendants and those sort of issues? Then we'll talk about benefit of criminal lifestyle, assumed benefit, if you like, and how that differs from the benefit of the offences, the particular benefit of the particular criminal conduct. And finally, I'm going to say a quick word about proportionality. Right, let's crack on. So the Law Commission was requested by the Home Office in 2018 to do a review of the law in part 2 of the Proceeds of Crime Act 2002 related to confiscation in England and Wales. The review has come out, it's over 600 pages. If you include appendices, it's over 700 pages. And there are over 100 consultation questions which you are invited to answer. Undoubtedly, there's a tremendous amount of valuable material in this consultation document, but far too much to cover in 30 minutes. And even over a longer commentary, and I'm splitting this into parts, even over a longer commentary, I'm inevitably being selective, and there will be things that I'm not mentioning that perhaps you might think I should mention. There is too much to read in full. What I would suggest is that you might try reading just chapter 1. If you haven't time to read 600 or 700 pages. If you read chapter 1, even that runs to just under 40 pages. It's a good summary of the whole of the material in the consultation paper. In practice, there are some useful ideas which could be implemented immediately. There are useful ideas in that consultation that don't require primary legislation. And there are other suggestions which would could be implemented without primary legislation, but quite a lot which do require primary legislation. And there's perhaps an issue as to whether they will ever come to fruition. One of them is revolving around the forum for confiscation. Currently, confiscation orders and restraint orders are made in the Crown Court by a judge, as we know, without a jury. Enforcement, such as triggering a default sentence, is dealt with in the Magistrates' Court. There is actually a power in statute to allow magistrates' courts to make smaller confiscation orders. It's in section 97 of the Serious Organised Crime and Police Act 2005, but it's never been activated. The consultation appears to favour in terms of forum, and as I say, I'm having to be quick here. I'm having to move very quickly over a detailed consideration in the consultation paper. What they appear to favour is only limited changes involving more training for Crown Court judges and the ticketing of judges for complex confiscations. So we've seen ticketing of Crown Court judges in relation to certain types of criminal case, sex offences and what have you, and they're suggesting a similar system of ticketing Crown Court judges for complex confiscations. They also mentioned that it would be possible for High Court judges to sit in the Crown Court where complex issues arise. That's something I can't say that I've often seen in practice. I have had experience in practice of I can remember one occasion in particular where a Crown Court judge was faced with the confiscation, and after about 10 minutes he said, I'm not doing this. I'm just not doing it. It's outside of my level of experience. I'm going to get it listed again in front of a different judge because it's just not something that I feel competent and experienced to deal with. And I thought that was quite brave of him, actually, to just say, well, you know, rather than make a hash of this, I'm just going to not deal with it at all. And we'll list it again for another day. That was some years ago. But yes, it would be possible for a High Court judge to sit in the Crown Court where complex issues arise and deal with a complex confiscation. Another suggestion that's in the consultation paper is the use possibly of an assessor. That is possibly a lawyer, possibly somebody with experience in another discipline, perhaps an accountant or a valuer or something, to sit alongside the Crown Court judge in certain cases. Now, I have to say my own view is that I'm not expecting that to happen. I would have thought that if the court required that sort of assistance, then one or other party to the confiscation, I say one or other, there might be more than two because you can have a third party with an interest. One of the parties to the confiscation would be bringing forward perhaps an expert witness who could assist the court with that sort of guidance, with that sort of information, with that sort of opinion. So I think that's more likely in practice than the use of an assessor actually sitting alongside the judge. Let's talk about continuity. There is an argument for continuity, and that is that the trial judge will be familiar with the offending of which the defendant has been convicted, and he may even have heard evidence from the defendant himself if during his trial the defendant is chosen to give evidence. Now, clearly, if that has happened and he's been convicted, then you might think, well, it hasn't gone too well for the defendant. And it may be that the jury, at least, have formed the view that the defendant is not a reliable witness. It may be that the trial judge has formed the view that the defendant is not a reliable witness during his trial. And so one wonders whether continuity actually is ever going to assist the defendant. Perhaps it is. Perhaps there are occasions when the argument can be put that as far as particular benefit is concerned, the prosecution proceeded on the basis of a certain involvement by the defendant, a limited involvement by the defendant in the offence, and that should be carried through to the confiscation, to the calculation of benefit of particular criminal conduct. One of the suggestions in the consultation paper is that where there is going to be a complex confiscation, that possibility might have been identified at the pre-trial hearing, PTPH, and a suitably experienced judge may have been selected by the court to hear the trial, so that judge with experience of issues relevant to confiscation will hear the trial and deal with the confiscation. And that way continuity will be preserved, and the best of all worlds will result. On the other hand, I would say that certainly from my point of view, the issues arising in confiscation, particularly if you've got a criminal lifestyle confiscation, may be very different from those arising at trial. Of course, the trial is all about a decision as to whether the defendant is either guilty or not guilty of the count or counts on the indictment. A confiscation is about how much benefit did he obtain. And in a criminal lifestyle confiscation, it's about an investigation into his previous financial life, going back years prior to the date he was charged. So this is very different territory from the territory that you're covering at trial, and it's for a different purpose. Of course, defendants do actually quite often change their legal representatives between the trial and the confiscation. And in my experience, that works okay. I've heard barristers say, well, look, very often I pick stuff up at confiscation stage. I've never felt disadvantaged by not having been involved in the trial. So if that works for the defense legal representatives, would it also work for the judge? And again, actually, the prosecution team dealing with the confiscation might also be different from those at the trial. You will find that there's a Section 16 statement drawn up by an accredited financial investigator, an AFI, and that person may not have been involved in trial at all, but they've picked it up subsequently, and they obviously feel able to deal with it. So if the defense team can be new, and the prosecution team can be new, and they cope all right, why shouldn't a new judge be able to cope okay with a confiscation? Of course, flipping that around, you could say, well, if the defense team are new and the prosecution team are new, it would be a blessing if the judge actually is the same one who dealt with the trial. At least somebody has some continuity. So there's arguments either way. Now, let's get down to the nitty-gritty, which is the benefit of the offences. And here, the consultation has quite a lot to say, and some fairly new thinking involved here. So what's the current position? Well, currently, benefit is based on property obtained. Obtained is the key word. English law is actually based not on ownership principles, but on title principles. And ownership effectively means that the person we describe as the owner has a bunch of titles and interests in the property in question, which allow him to treat it as his own. There isn't, strictly speaking, a title called ownership. There are various levels of titles and various bundles of power and control over an asset and use. Confiscation's case law is interesting because if you read the statute, if you read POCA and just take it literally, black and white, absolutely as it says, then it is written, I think one of the law lord described it as having a certain amount of overkill. It is written in order to not allow too much scope for people to squeeze around the sides and evade their responsibilities, if you like, in relation to confiscation. And nowhere is that clearer than in section 84, I think it is, which deals with property and what is meant by obtaining property and what is meant by an interest in property. And effectively what that says is that if anybody has any interest in property, then that's it. They can have obtained that property. So, for example, if I steal somebody's watch, I don't obtain good title to it, but I do obtain what's referred to as possessory title. I have possession of it. And that possessory title is some title. It's better title than somebody who has no title at all, but obviously not as good title as the true owner. So in terms of confiscation, because I have possessory title of that watch that I've stolen, then I have obtained it, and it is a benefit of my criminal conduct, a benefit of my theft. Well, there's no problem with that. That makes some sense. But what about then a courier of money? If I am carrying a holdall with £100,000 in cash in it, I have possession of that. I must have, surely, possessory title of that. But in terms of confiscation, we are treated as, we treat the courier as not having obtained money which he is simply carrying about to deliver to somebody else. So arguably, confiscation case law doesn't actually follow every dot and comma of the black and white statute in that respect. And that is one of the criticisms that the Law Commission make, that the present arrangements don't really follow the black and white law. Also, they say benefit figures can be excessive, for example, where property is jointly obtained. If we take the case of, let's say, a group of 4 burglars who break into an art gallery and steal a painting worth £100,000. Under the present law, they will have been deemed to have jointly obtained that painting, and each of them will have a benefit of £100,000. Now, you might say, well, that's just unrealistic. That just doesn't make, in a real world context, that doesn't make sense. In a legal context, it makes sense, but in a real world context, it doesn't make sense to say that each of the 4 burglars has a benefit of the full value of the painting. There are some inconsistencies. For example, I mentioned a few minutes ago a chap who has a holdall with £100,000 in, and confiscation law will treat him as not having obtained that £100,000 that's in his possession if he's merely a courier taking it from person number 1 to person number 2. But what about if he does exactly the same thing, but instead of having a holdall full of banknotes, he passes it through his bank account? He gets person number 1 to transfer £100,000 into his bank account, and he transfers that out to person 2. Well, in that case, the confiscation position is quite different. In that case, case law will say he has obtained a benefit of £100,000 because when that £100,000 was in his bank account, it was his money. He had title to it, he had obtained it, and therefore that's his benefit. But isn't that inconsistent as between the physical movement of the cash in the holdall and the bank movement through the bank account? And the consultation paper also suggests that in some cases, the benefit of might be too wide-reaching or wide-ranging, and tax evasion. And there's quite a lot of talk about importing tobacco and so on. And when does the liability for tax, for duty on that imported tobacco, when does that arise? Who is liable in confiscation? And it's suggested that perhaps the liability attaches to the wrong people in terms of confiscation. So what do the Law Commission favour? Well, they are suggesting a change of approach in the primary legislation. They are suggesting that instead of the concept of benefit obtained, we should look to a concept of benefit gained. And they are saying that the idea of what one gains from a criminal offence can be found in the Fraud Act, can be found in the Theft Act. They are saying this is something that courts are familiar with dealing with, the concept of gain. And they are suggesting, perhaps in the case of my 4 burglars and who stole a £100,000 painting, that perhaps they didn't each of them gain £100,000. What each of them gained perhaps was their share of £100,000. What each of them gained, let's say, split it equally, what each of them gained has been £25,000. And they're suggesting that that might be a better approach to confiscation, to say, let's not look at what's been obtained, let's look at what's been gained. And they also say that where relevant, the court should be allowed to have regard to the intention of the offender with regard to the property. Now here we come back to the courier. The intention of the guy with the holdall with £100,000 in it is to pass that holdall on to person 2 when he arrives at his destination. It's not his intention to gain that £100,000. And in exactly the same way, the person who passes it through his bank account is not intending to gain that £100,000. He's intending to pass it on. And so, say the Law Commission, shouldn't confiscation have regard to the intention of the offender, so that our money launderer through his bank account is treated in confiscation in exactly the same way as our money launderer with the holdall. So that's the proposal. Obviously, that wouldn't happen without a change in primary legislation. So, as I've said, the Law Commission views that the concepts of gain and of intention are well understood in the criminal courts, and adopting the concept of benefit gained would remove difficulties associated with the offending by multiple defendants. And where relevant, the court, having regard to the intention of the offender with regard to the property, will assist in cases like that money laundering case. Now, if you read the consultation, there is a lot more discussion of this in there, and I feel that I'm not quite doing it justice in a few minutes, but that is the thrust of it. Let's abandon the concept of what has been obtained, and let's look instead at what has been gained. So what's my view? Well, what we're doing here is we're making the law more flexible. We're allowing the courts and judges to form a view as to what the defendant's intended gain was, to form a view as to what the intention of the defendant was. Whether that will appeal to government and parliament, I have some serious doubts, because it seems to me that POCA in 2002 was originally designed to remove from courts as far as possible any discretion with regard to confiscation. And what the Law Commission is proposing here is to give the courts discretion to look at the circumstances of individual cases and act accordingly. And we'll talk a little bit more about discretion in relation to assumed benefit as well. Of course, abandoning the concept of what's been obtained would render a lot of case law, existing case law, redundant. You might say, well, that's the idea. And potentially, it seems to me that a shift from obtained to gained would create problems if you are revisiting and varying existing confiscation orders. I'm thinking here of Section 22 revisits and revisions, where the court is asked to say what is just. How does the court approach that if we've got a confiscation order made under the old POCA provisions based on obtained, and since then the law has been changed so that we now look at what's been gained? Should the court be looking at revising an old confiscation order based on what it might have thought was just under the new regime? I don't know. So I mentioned criminal lifestyle and assumed benefit. Let's talk about that. It would appear that the rationale for the criminal lifestyle assumptions is basically that they should be applicable where there's a higher risk that a particular defendant has had more extensive criminal conduct than that which is before the court. And so his benefit of other criminality of which he's not been convicted is going to be picked up by the statutory assumptions. One of the tests for criminal lifestyle is that the offence has been listed in Schedule 2. And the Law Commission suggests that that continues, and they suggest only a minor amendment to Schedule 2. One of the things about Schedule 2 that interests me is that cultivation of cannabis, which I think is Section 6 of the Misuse of Drugs Act, is not a Schedule 2 offence, but production of a drug under Section 4 is. And it seems to me that what happens very often is that if you've got somebody who's been cultivating cannabis, he is at risk of being charged with production rather than cultivation. And the reason for that is because it's a Schedule 2 offence. So I wonder if there's a bit of an anomaly there with relation to cultivation of cannabis, but that's not a point that comes up in the Law Commission consultation. The Law Commission do suggest that it's anomalous to require 4 counts on the same occasion. So where a person is convicted of more than 3 counts in the same proceedings before the Crown Court, then they have a criminal lifestyle if each of those proceedings produces some benefit, and if the aggregate benefit is at least £5,000. But in terms of somebody who's been to court repeatedly over a period of time and been convicted on different occasions, then they only need to have been convicted on 2 prior occasions. So 3, including the current one. And the Law Commission say, well, why is it 3 counts under subsection 3B and 4 counts effectively under subsection 3A? They suggest that those 2 ought to be levelled up. They also suggest that offences which are taken into consideration, TICs, should be treated in exactly the same way as convictions. And as you will know, at the moment, the benefit of an offence taken into consideration counts towards the £5,000, but the actual offence itself doesn't count towards the number of offences. And they suggest that the benefit of an unsuccessful attempt should be counted towards the total number of trigger offences. An attempt to benefit by an unsuccessful offence and a conviction for an attempt, in effect, should be counted as a conviction for this purpose. They also say that the £5,000 limit that was set in 2002 needs to be revised, and it should be somewhere around about £9,000 or something like that if it's uplifted for inflation. What they don't mention is that the monetary limit in Scotland is very much lower, but of course they're not covering Scotland, so there we go. They go on to suggest, and these are some novel ideas, that the prosecution should have a discretion not to apply the assumptions. That the prosecution should be in a position to be able to say, looking at this offender and this offence and this particular case, we're just not going to apply the assumptions because we don't think we should. Not because he doesn't have a criminal lifestyle, he does, but because we don't want to. And similarly, the Law Commission suggests that the court should have a discretion to decide that the assumptions should not apply. Now, at the moment, a court can throw out a confiscation entirely on the basis of abuse of process. It doesn't happen very often, and it's not particularly encouraged. But a court doesn't have a discretion to say, yeah, we'll go with the particular benefit, but we're not persuaded that any of the assumptions apply or should be applied. And they also suggest a little more nuanced that the serious risk of injustice test be clarified with respect to property held since the date of conviction. For example, I purchased the property myself in 1979 and I still have it. If I was convicted of an offence and found myself in confiscation, facing assumed benefit, how do I prove that that property purchase in 1979 was from legitimate funds. I've got a difficulty, haven't I? Because I haven't got any paperwork going back that long. The bank and the building society and so on won't have paperwork going back that long. So am I then in a position where I can't displace the assumption, and I'm going to get stuck with the benefit of the current value of that property purchased 40 years ago? Well, the Law Commission suggests that the judge be allowed to consider why it is that documentation hasn't been produced, and if there is good reason, as in that case perhaps, why documentation couldn't be produced, then the judge should be permitted to say that's a serious risk of injustice and not having that assumed benefit. And that is particularly in relation to assets held after the date of conviction, because those assets can be assets that have been acquired so long ago. The thinking is that if we're looking at the normal transactions since the relevant day, well, that's only going to be 6, 7, 8 years ago. And so the paperwork should be able to be found. But in terms of assets held since the date of conviction, as in my case, that could be something from 40 years ago, and there won't be any documentation. Yeah, my own view is, again, making the law more flexible may not be welcomed by government and parliament. In my experience, prosecutors actually do sometimes exercise discretion in operating the assumptions. We see that, for example, where they will say, right, I'm not going to operate the expenditure assumption because of the risk of double counting. Okay, fair enough. But I've also seen cases where in a Section 16 statement, the prosecutor will say, yeah, okay, the relevant day is in 2012. I know from this case that the offending started in 2017. I'm going to apply the assumptions only from 2017 onwards, only from when the offending started. Now, you might say, well, actually, that's not really catered for in the legislation, but I've certainly seen prosecutors exercising that discretion, whether they're actually permitted to or not. And of course, these suggested changes would make contested confiscation hearings, I would have thought, much more common, because then you've got the chance, haven't you, that if you go in front of the judge and argue it, he might exercise his discretion in favour of the defendant. So the defendant is going to be more keen, I would have thought, to give it a whirl in front of the judge rather than do a deal with the prosecution. As you know, in practice, very, very many confiscation cases are settled by agreement rather than by a contested hearing in front of the judge. And that proportion might change, I think, if these ideas were adopted into law. Just quickly on proportionality. The Law Commission discussed proportionality in the context of benefit, and I absolutely understand why, because we are looking at proportionality at, for example, where the benefit of the offence has been returned to the victim. And so you can say to me, well, proportionality, yeah, it's all about benefit. But actually, if we look at the case of Weyer, and if we look at the amendment that was made to Section 6 in subsection 5 of POCA, and the way that the legislation is written down, proportionality applies to the amount that the defendant is ordered to pay. What POCA actually sets out is that you work out the benefit, you work out the available amount, you take whichever of those is the lower and you call it the recoverable amount, all at that stage without considering proportionality. And then, according to the statute, then and only then, the court asks itself, would it be disproportionate to order this defendant to pay the recoverable amount? And if it would, then the order should be reduced to a figure which is proportionate or is not disproportionate. So there's a question mark in my mind as to whether the discussion of proportionality actually belongs under the heading of benefit, or actually belongs under the heading of the amount ordered to be paid. Now, there is a problem there, isn't there, in that if we decide, or if the court decides that the amount is disproportionate, or that there are factors within the benefit which might have caused it to be disproportionate to order the defendant to pay the whole amount of the benefit if he had that available amount, but he doesn't have that available amount, so the issue doesn't arise. So proportionality needn't be considered when making the confiscation order. That's all well and good, but what about when we come to a Section 22 revision? Here then, under Section 22, and we'll discuss that in a fortnight's time, under Section 22 we revisit and we look at amending the amount ordered to be paid. And that can happen some years after the original confiscation order. Well, is that now too late for the court to be aware of proportionality issues? So does it actually make a lot more sense for proportionality to be considered in the context of benefit right at the start, so that these proportionality issues can be thrashed out then, rather than being left to be looked at some years down the line under Section 22? But proportionality derives from A1P1, and that relates to depriving an individual of his assets, of his property, which takes you back to the amount ordered to be paid. So there's a bit of a conundrum there. As I've said, in my view, proportionality under Wales and under Section 65 relate not to benefit, they relate to the amount ordered to be paid. Okay, we've run over the time a little bit. Just a quick reminder of how Bartfields Forensic Accountants can help you. We remain fully staffed, undertaking legal aid and privately funded criminal and civil forensic accountancy work. Fortunately, we've got on the IT, we can work remotely. There's no problem with any of that, despite the pandemic. We remain readily contactable by phone and email and video. And our website is full of useful information, articles, and so on. You can see more on this topic and our other seminar topics on the website. The links are there on the screen. We will send you a recording of this webinar in a few days' time. And if you have any questions, do please email me, and I will be happy to answer any questions you have arising out of this webinar. My email address is there, and the office phone number and the website. I have run, I think, 8 or 9 minutes over my time. Apologies for that. There was a lot to get through. Thank you for your time. Thank you for listening, and we'll see you in a fortnight. Thank you. Goodbye.